True. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district? Sign these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Right from the start, the judge is stressing the importance of understanding this plea deal. Notice how she breaks it down: dismissal of one case but a reduced charge still sticking. This is the legal system's way of balancing leverage and mercy.
And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 240534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case, and they're also agreeing that if anything that I...
Got these right there.
Everything, all of them except 0534. Good morning. Are you Bryce Thomas?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor. We're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third degree.
So is we can do it. Y'all can get it done as soon as I'm finished. I'll just go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right?
Here as something critic, I'll be waiving his right to appeal. The defendant is basically agreeing that this is the final word, no going back later if he doesn't like the outcome. Would you take that deal?
To appeal the dismissal. Gotcha. Okay. Give me just a second. Yeah.
And the lesser included is instead of the first, is
Third. 0354 has been dismissed, I think. Or 0534, whatever I said. Mr. Thomas, in cause number 24, DCCR 0389, you're charged with the third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 24-0390, you're charged with the third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with the state jail felony offense of theft of a firearm, and that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then what is the reduction to? In cause number 24 DCCR 0392,
and here's the jaw-dropper: indecency with a child by exposure. A charge like this isn't just prison time, it means lifelong consequences, including mandatory sex offender registration. This is where the stakes skyrocket.
the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure. And that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 240534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case, and they're also agreeing that if anything that I sentence you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under...
The judge reminds him, pleading guilty has immigration consequences and requires sex offender registration. These aren't just courtroom words. This can reshape someone's entire future. What do you think? Is he fully grasping the weight of this?
Federal law. Also, in that indecency case, do you understand that you will be required to register as a sex offender? And Mr. Burbank will go over that more with you today, and there's a document you need to sign today with regard to that. And do you understand that as well? State tenders number 1 in each case.
No objection. States 1 in each case, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done. That'll give me more information about you, your cases, and we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Burbank. He will present it to me on your behalf when we come back. All right? You can go back with the bailiff. Yes, sir. And I'll give you a minute to talk to Mr. Ramon.
Send it back to a cookie.
Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. And that probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew.
Now we shift cases. Michelle Leos is on probation for child endangerment, and already there's talk of drinking curfew violations and even drug seeking. Probation is a second chance, but the court's patience is clearly running thin.
Failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request safety, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SAFE-P. What I'm asking the court to do is hold the SAFE-P in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay. Whether it be 14 days, whether it be 30 days, I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the safe P in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if safe P is still in her actual best interest at this point. We understand that safe P is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
Do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if it feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to safe.
The defense blames medication changes for Michelle's behavior, but notice the judge's hesitation. Courts have seen this story before. Excuses, broken promises, and failed programs. Will the judge buy it this time or enforce tougher consequences?
And now wants to do things on her terms. I think safety is where she needs to be based on the relapse and violations she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Rudis can testify to that, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SafeP if she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that? Yeah. I think based on what I know now from the beginning, that we ordered or agreed or whatever happened with ISF, and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue, and so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know that's not what you want. I hope you take advantage of it, however. It's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you, Mr. Ruiz, for being here as well. All right, are you Leonard Dale Idleberg?
Yes.
And this is cause number 1625968. Mr. Idleberg is on probation for Driving while intoxicated, third or more. A motion to revoke has been filed, and Mr. Cole has filed a motion asking that I set a bond in this case. And it looks like the allegations from that motion are that Mr. Idleberg, while on probation, allegedly committed the new offense of driving while intoxicated, third or more, January 9th of 2025 in Chambers County, Texas, that he left Jefferson County without permission, that he drove a vehicle that did not have an interlock device on it, that when he was stopped, the allegation is the intoxilizer that was administered provided breath samples of 0.108 and 0.115 and behind in his fees a little bit as well. Mr. Cole?
Well, Your Honor, I think since the time that Mr. Idleberg was put on probation in 2017, up until this latest incident, his mental capacity has changed dramatically. He's been diagnosed with Alzheimer's. He's on the verge of his nerves inside of his brain have shrunk. So on top of the Alzheimer's, he's has the possibility of having a stroke. So I think that this is him not remembering the conditions, and his wife is here that can, his keys, you're taking his keys. We do have paperwork that I gave to counsel that can, from the doctor showing that he does have Alzheimer's. He was diagnosed in March with Alzheimer's, and the nerves in his brain are shrinking. Your Honor, he's unaware that he even violated the condition.
Well, that makes it even scarier for me.
That I know it does, but we're asking that we get him out, and his wife is going to take care of him and make sure that he doesn't drive that car anymore. Take the keys, now that we're aware of.
Why don't you, if you want to put on a witness, that might help.
I'd call Gwendolyn Brown, please.
Okay, Ms. Brown, come on up, ma'am. Do you have some documentation about ma'am? And your name, what was your first name?
Gwendolyn.
Gwendolyn Brown. And Ms. Brown, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Cole.
State your name for the record.
Gwendolyn and Outburst.
And how long have you known this gentleman right here?
We've been married 13 years.
13 years. And when did you start noticing deterioration in his mental capacity?
Back in December last month, last year, 2004.
I guess another question I want to ask you is,
Can you speak up, please?
what are you willing to do to ensure that Mr. Idleberg no longer has access to his vehicle?
I will take the keys from him. He will not drive anymore. Nothing. I already had the keys. I can't drive anymore. He will not drive anymore. He will not drive anymore. I will take the keys from him, and he will not drive.
And do you think that in the situation that happened in Chambers County, do you think that he was aware of the conditions of probation that he was violating?
No, he wasn't aware because his probation told him that she was done with him. So when you say you're done with somebody, that means you're done with them. You thought he wasn't on probation anymore.
So there's a lot going on upstairs, Your Honor. I don't want him showing back up in a red suit. I know she can care for him outside of this facility that he's currently in right now, which is in jail. We have a court case in Chambers County that we would like to be at. And I don't think that he was intentionally violating probation. I think that he, at this point, his mind is, so he's getting lost. He doesn't know whether he's coming or going. And I can have a conversation with him right now and he'll forget it in the next 2 hours. So, it's one of the
Thank you, ma'am. You can have a seat.
I just want to say one more thing.
Yes, ma'am.
When he was in jail in Chambers County, the probation officer told me to bring him to her as soon as I get him out of jail, right? So I brought him to her, and then she called his name, and I was going upstairs with him, and she said, "Miss Idleberg, you have to stay downstairs." So she went. She said, "Only me and my supervisor need to talk to him." So my supervisor talked to him, and when he came back outside, I said, "What did she say?" He said, "Nothing." She said, "Go home." But she had told him to go turn himself in to Jefferson County. And he didn't remember by the time he got back to the court. So he would have been in jail.
Right. Thank you, ma'am. Ms. Malfino, based on...
Obviously, I have the same concerns to the court based on the representation of his wife, that he won't be driving. That gives me a little bit of comfort. I did speak myself with Ms. Hunter. I know she's probably just told him what the rules are, and maybe he doesn't understand them, but I know she hasn't been combative with him. She initially told me she doesn't oppose him being a bond. I don't know if she's aware of these medical conditions, but, the driving factor. And obviously, you couldn't go somewhere like mental health, safety, or anything like that.
No, not with that diagnosis, and I don't think with that diagnosis either. Let me look at something else. All right, so what I'm going to do in this case is set a bond. I'm going to set the bond at $5,000. I'm going to order that a condition of that bond is that Mr. Idleberg not drive ever. And I'm doing that on the representation that the keys will be taken away, hidden, whatever's necessary. And so I'm looking at you, ma'am, that you are giving me that representation to make me feel comfortable that he doesn't get the keys somehow and drive. So just sticking them in your purse or sticking them in a drawer with this type of diagnosis is not going to be good enough. I'm going with your assurances that you're going to take care of that. Obviously, you don't want anything to happen to anyone else in the community as much as I don't. So I'm going to do this based on the fact that you're giving me those assurances. And then obviously there will not need to be, if there's already an order for an interlock, I will allow that to be. Is there an interlock?
Yes, Your Honor.
Yes.
But he's done.
Well, I know we want him to be done and we're saying he's done. You're able to drive the vehicle with the interlock, correct?
I can't breathe. You talking about breathing?
Y'all don't have, how many cars do y'all have?
I have one car.
Okay,
This car is gone.
it's gone.
Right.
So I won't require an interlock on her vehicle so that if he doesn't have, if that's gone, then we're fine with that. Any other condition other than the no driving and her assurances that you can think of, Ms. Malfino?
No,
All right, we'll reset it for an announcement on that MTRP.
well, may I just inquire, Judge, before that hearing, is it Mr. Mr. Cole, your representation to the court that you believe at some point in time your client will be able to enter pleas of either true or not true to this motion, or do we need to make some other?
I believe that he'll be able to make pleas are true or not true.
Okay.
Yes.
Once you have more time to visit with him as well, if there's an issue because of the diagnosis with regard to competency, we might have to try to just see where we are on it all. All right.
Thank you.
Thank you. You can go back with the bailiff. Yes, sir. Good morning, sir. Are you Theodore Brisco?
Yes, ma'am.
And Mr. Brisco, in cause number 234535 is on probation for evading arrest or detention with the use of a vehicle. And in 236055 on probation for possession of a controlled substance.
Yes.
Motions to revoke those probation have been filed. Mr. Parker, announce.
Your Honor, just for the record, I went to see him at the jail and they told me he wasn't at the jail.
Oh,
So I didn't get to visit him, and
Okay.
he was here. I got to visit him this morning. I think I told him that the court would probably give us more time to go over it if we wanted to, but I think we just need to go through the motion without an agreement. I think he understands that. Also, there's a drug charge that hasn't been filed yet, just for the court's knowledge.
and so Mr. Brisco, we can go through those motions today, get pleas of true or not true, or I can reset your case just a few weeks if you need more time to visit with Mr. Parker since he, okay. So let me get that pulled up.
And they're the same violations on both cases, Judge.
Can I get 36055 printed, please? Oh, no, that's okay. I gotta make marks on it. Thank you. It's just hard to do when I do them both on the computer. All right, in each of these cases that we've talked about, Mr. Brisco, I have motion to revoke your unadjudicated probation. In 20-34535, the motion shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? And in cause number 20-36055, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of possession of a controlled substance, and that was also a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation, Count 1 in each of the motions alleges that you committed the new offense of possession of a controlled substance January 5th of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 in each case alleges that you committed the offense of assault causing bodily injury to a family member January 5th of 2025, and is that true or not true? Count 3 alleges that you committed the offense of the new interference with an emergency request for assistance January 5th of 2025, and is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours as required, and is that true or not true? And count 6 in each case alleges that you were behind in your court-assessed fees, and is that true or not true? Did you enter your pleas of true in each case to counts 1, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 1, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Mr. Nichols, does witnesses for either of those cases?
Yes, Your Honor. I'll have to call witnesses to prove up the two that
Sure.
are not true to.
Do you anticipate that taking longer than an hour or so?
I do not, Your Honor.
Okay, we'll just set it maybe at 11 on a regular docket day. I will ask probation to do an updated pre-sentence report. Mr. Brisco, obviously anything that you think is important for me to know, make sure and get that information to Mr. Parker. He will present it to me on your behalf when we come back.
Yes, ma'am.
All right, we'll see you back at sentence. Yes, it's unagreed. God bless you. Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 241369, is charged with the offense of murder. There was a request for a competency evaluation that was done by Dr. Grapon. I'm going to take judicial notice of the court's file. We have received that evaluation dated May 23rd of 2025. Dr. Grapon, after that evaluation, makes the finding that Mr. Rose is currently competent to stand trial. Is there any other evidence with regard to competency? Mr.
Not for
Burbank?
defense, Judge.
No, Your Honor.
Then at this time, I am going to find that Mr. Rose is competent to stand trial. Mr. Burbank, announcement?
Your Honor, as you are well aware, I'm the second one.
Right.
I just need one more announcement, 30 days or 40 days, and we may be able to.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor. State's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like you've got an investigator involved and you've taken care of that.
We do,
So,
and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this now.
all right. What I'll do to make sure your investigator, you have plenty of time to get up to speed, is reset it 45 days and expect an announcement on that date.
Thank you.
All right?
Maybe
Thank you.
excuse to that time.
Yes, sir.
Thank you, Judge.
Good morning. Are you Jennifer Bowles? Give me just a second here. And will Ms. Bowles waive the formal reading of the motion? Ms. Bowles, in cause number 18-29814, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2019 for the offense of fraudulent use or possession of identifying information. That was a third-degree felony, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample October 24th of 2023 that tested, and October 25th, that tested positive for methamphetamines, amphetamines, and is that true or not true?
True.
Count 2 alleges that you provided a urine sample January 25th of 2024 that tested positive for methamphetamines and amphetamines, and is that true or not true?
True.
Count 3 alleges that you failed to provide verification of attending the DROP program January 2nd, January 17th, January 20th, January 29th, and February 5th of 2024. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of January 25th of 2024 in the amount of $4,972.61. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Ms. Bowles is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will also run concurrently or at the same time with the Orange County case that you're currently serving any time on. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Parker. Good luck to you, ma'am. Thank you for being here, sir.